Good evening, everybody. It now falls to me as my happy first duty as your new ELS chairman to introduce a long-standing and hugely popular member of the Society, John Bullimore. We're delighted that John has agreed to speak to us this evening. John is well known to many of you as a Chancellor of 30 years experience, having first been appointed in 1980 at only 12 years call, a mark of John's exceptional ability and deep commitment to the Church. Few of you will perhaps know of John's successful career at the bar, where he was known as a fearless and eloquent advocate, followed by his appointment to the circuit bench in 1991, where his patience tinged with subtle irony, kindness to those appearing before him professionally, legal ability and insight into human nature were legendary. We very much look forward to hearing what John has to say to us this evening. And without further ado, John, over to you.
Thank you very much, Lizzie. I don't know who writes this stuff for you, but anyway. Good evening, everybody. It's good to be here, and I'm glad you've been able to join in for this evening's lecture. The flyer for this evening described me, when it went out, as a retiring Chancellor. Well, I'm now retired. Tim Clark has taken over as Chancellor of Derby, and Judge David Hodge, one of Her Majesty's councillors, taken over at Blackburn. Tim is a member of the bar, but he's also ordained, so he joins that small band of chancellors who are also members of the clergy. David was appointed as Chancellor of Oxford a little over 2 years ago, I think. So now with Blackburn, he's got a full house of chancellorships. He can't have any more. The flyer also promised that I would provide some guidance this evening. Well, as the preparation got underway, it became, certainly became more doubtful about that. I'm going to go for a more modest aim of providing some reflections and comments. These will be in a relatively informal way. I also want to try and respond a little to an earlier lecturer, and then move on to various diverse aspects of the faculty jurisdiction. For those of you who aren't really interested in faculties, which would be amazing, of course, if people weren't, but for those of you who aren't, I hope you've at least got some knowledge of the jurisdiction. You'll be pleased to know that I've never kept any records of the cases I've had to deal with, so most of them have passed completely out of mind. Occasionally, some recollection has stuck, and I may refer to it, but I'm not going to dip very much into my anecdotage. The things I comment on later have been shaped really by my personal experience as a Chancellor. I've learned a huge amount from other Chancellors, and I'm not going to identify them further than that. But also I've learned from registrars, from archdeacons, DAC members, contacts with the amenity bodies, which have normally come to me in an indirect way in the course of a case. And of course, clergy and lay people in individual cases teach you an awful amount. So thank you to all of them. The role of being a Chancellor in two different dioceses over several decades has been a challenge, it's been a great privilege, been interesting certainly, and enlivening, and I wouldn't have missed it for anything. As you know, Chancellors are concerned chiefly with the consecrated buildings and churchyards of the Church of England. The usual figures are that there are some 16,000 churches, and of these, about 13,000 are also listed in accordance with the secular legislation relating to these things. So a large proportion of our buildings are recognised as of great historical and architectural interest, a significant part of the country's built heritage. Our retired Dean, Charles George, stated in a recent article that over 50% of our church buildings are in fact in the two upper grades, grade 1 and grade 2 star, which is remarkably high on any view. Churches, of course, range in age over a vast period, certainly from Saxon times onward. The last great age of church building was in the Victorian age. So even those are now of some considerable age and are likely to be showing all the deteriorations that age causes. These buildings are significant structures, obviously, but they mean much to their local communities as well, even if for many people it's simply the big building in the village or the town that they rarely enter. For the congregation that goes there, the church serves many purposes. It's a place to gather, to worship together, to socialise, and it's a base for the service that they offer to the local community. And along with the churchyard, it focuses memories and hopes for the future. And there's a very strong sense among many people that a particular church building is our church. The day-by-day costs of running things from there falls mainly on local people. Although for more major repairs, local people may chip in, even if they don't otherwise support the church. But there are some grants from public funds and charitable institutions which are sometimes available, and they're always gratefully received. I'll say that, having been a church warden myself at times. The local church is there not only to care for the local congregation of worshippers, but also serves those living in the locality and the parishioners. And it isn't a private building. People have a right to come in, to attend the public services. And of course, many also take an additional role. Apart from these activities, they play an active role in the life of the church in a variety of ways, including by becoming wardens or PCC members or other officers of the church. So the faculty jurisdiction on any view has to cater with a great number of things, has to cater for all sorts of categories of people: the clergy, the lay leaders, regular and occasional attenders, or those who just drop in, visitors, if you like. Those who choose to have some one-off involvement, perhaps in connection with a particular memorial, or because they don't like some projected change which the PCC are wanting to implement. But it also involves those who have a wider focus on what the church represents in terms of historic and architectural interest, its value from a heritage viewpoint. And the procedures that we have to deal with all these different people and all these people with different interests. And judges need to be aware of the often conflicting viewpoints that all these stakeholders have. It seems to me, having done this for a long time, although we don't spell it out very much, that we have to be conscious that without a purpose to serve, any building will quickly become neglected and subject to the weather and general deterioration. And if faith and worship decline far enough and numbers fall away sufficiently, we simply have another shell of a building in which some clever architect will want to try and fit apartments, or possibly a bookstore or carpet repository, whatever it is. So I think it's also important for chancellors to have in mind that they need to do what's possible to preserve and encourage a caring community for the church building, so that the people who are involved with it can continue to be the church in and from that place. And in turn, they can look after it. We are not called simply to make rarefied decisions about historic buildings, apart from the hopes and aspirations of the people concerned with it as a local outpost of Christ's church. We're not simply a branch of the National Trust with opportunities for prayer. And many of the most challenging cases involve, obviously, change and alteration to these venerable buildings. And the main principles for deciding them are contained in what are known as the Duffield Guidelines. These were first formulated by the Court of Arches in a case arising initially in the Derby Diocese in 2012 at St Altmans in Duffield. In fact, this is the village where the Bishop of the diocese lives. He's up there, or she in this case, is up the other end of the village from the church. At first instance, it was a decision of mine. It concerned a proposal to relocate the chancel arch within this Grade 1 building, and it was a petition I refused. Well, that was overturned on appeal by the petitioners. Rightly, I accept. And the Duffield Guidelines were formulated to help others who were having to deal with other contested applications where changes to listed buildings and local needs appeared to be in conflict. It's interesting that the guidelines were advanced in the appeal judgment in a very tentative way. Chancellors may feel the following could be of assistance, sort of a fashion. However, by 5 years later, the date of Mark Hill's 4th edition of his book on ecclesiastical law, they were recognized as having become the right way to go. In effect, they were mandatory. They sought to balance, on the one hand, any harm to the significance of the listed building, something which later cases said had to be very carefully identified, and any benefits that it was hoped to achieve. As I say, I concede I made an error in the way I received evidence at first instance. And the Arches Court were well justified in setting my decision aside and deciding afresh. But one guide point, if you like, coming out of all this, it's a memo to all chancellors: always swear the witnesses, even if you think they're only going to give you their opinions and arguments, why on undisputed facts you ought to go down one route rather than another in making your decision. I thought it would be interesting, at least, to try and respond to an earlier lecturer, which I don't think we've done before. And I wanted to pick out what I thought was the most challenging point made by Kate Davey in her address to the Society last November on the Amenity Society's listed buildings and the parish. She spoke as a trustee of the Victorian society. And the views that she put forward were obviously those of the society as well. But I dare say other amenity bodies would share the same stance. Was it right, she asked, that where issues arose between one or more immediate amenity societies on the rightness of proposed changes to a listed building and the needs and wishes of the local congregation, that the matter should be decided by someone who was required to be a member of that same Church of England? It's a question I think that needs to be taken seriously. In essence, she was suggesting that the home team, the church, always had these matters adjudicated by someone who was a paid-up member of their supporters club. And the amenity bodies were, and certainly felt, disadvantaged thereby. She suggested too many decisions simply went with pastoral needs as generously discerned by the Chancellor, and not enough weight was given to genuine heritage concerns. Well, there are quite a lot of qualifications before you can become a Chancellor. Consistory court of the diocese, where he or she sits, is the bishop's court. It's to be presided over by a single judge. They have to be 30 or over. Most of us qualify very easily for that. That's like a bishop, of course. So I suppose it's 30 is a mark of some sort of maturity in wisdom and judgment. I suppose that's the reason. The judge is known as the Chancellor in all the different dioceses, apart from Canterbury, where, for reasons that they will know, the judge is known as the Commissary General. By law, anyone appointed to the office of a Chancellor has to have held high judicial office. That's a term of art. I think that's rather more than what the newspapers call a top judge when something's gone wrong somewhere. Or they have to be a circuit judge, or at least qualified for appointment as such. And the purpose behind these provisions must be that anyone who becomes a Chancellor has a number of years' experience in the practice of law, and probably has good experience of sitting as a judge in ordinary courts and adjudicating in relation to conflicting evidence and arguments. Lord Denning used to say, I never heard him say this, but it's reported this is what he said, that the job of a Chancellor was something for a member of the junior bar. So I think he'd be surprised by the present position. The list of current or recently retired Chancellors shows many are indeed circuit judges. Many of these, of course, have been leading counsel. There are some junior members of the bar, but because of the various other restrictions, they've had many years of experience of appearing in court, so they're senior in that sense. There has been, in the past, a smattering of High Court judges and even one or two members of the Court of Appeal, though I suspect that they've all been chancellors before they were appointed to these other offices. And they all have to be sworn in before they take up their duties. The canons tell us what they have to swear to. They're in Canon G2. They're not in this order where they're mentioned there, but they have to take the oath of allegiance to Her Majesty. Most of them are lay people, of course, but they're required to make this declaration: I, AB, whatever the name is, declare my belief in the faith which is revealed in the Holy Scriptures and set forth in the Catholic creeds, and to which the historic formulas of the Church of England bear witness. It's like a priest before ordination or being admitted to some new living. So it's a pretty full-on declaration of agreement with the foundation documents of the Church of England. Also, they have to swear that they will, to the uttermost of their understanding, deal uprightly and justly in their office, without respect of favour or reward. No partiality. Also, if they're a new chancellor, if the new chancellor is a layperson, the bishop must be satisfied that they're a communicant. So those who framed these requirements in the first place obviously felt it was possible for the chancellor to be both an adherent of the Church of England in a strong way, and at the same time to be able to judge fairly between the various viewpoints which are put before them. They also have to be knowledgeable, as we've seen, of the beliefs of the Christian faith as the Church of England understands it. And as a communicant, they must have lived experience of the life of the Church. I think any suggestions for alternative adjudicators, to use a fairly neutral term, will need to reckon with the requirements that there are now in place. I did find it interesting to discover that when someone was appointed as the registrar of a diocese, the canons require that they are learned in the ecclesiastical laws and the laws of the realm. That's not a requirement which is imposed on would-be chancellors, however sensible you may think it is. I've no idea why that is, and I suppose you'll have to make of it what you will. Let's go back to what Kate said to us in November. Chancellors were too much influenced by so-called mission or pastoral matters as parishes put them forward, even if they were not really pressed in a very strong way. And she also indicated that chancellors were not sufficiently knowledgeable about and sensitive to heritage issues in dealing with these nationally perceived important buildings. And the solution, as she put it forward, as I understood it, was that there were to be panels to adjudicate on these special cases, made up of those with particular expertise in matters relating to historic buildings and heritage issues. They're not going to be a sort of super DAC, and as I understood it, they're not a panel from whom a specific individual is to be chosen to adjudicate on the particular case. Rather, it's going to be a panel. So having several people to decide on something may sound very agreeable, but I think it's likely to be more cumbersome, more expensive, and possibly slower. And believe me, questions of delay are still very much at the forefront of problems in the system as parishes see it. If there are going to be a panel, as Kate suggests, and this would be true even if there was only to be one person appointed, there are going to be decisions made by two different groups of judges in regard to the same church building, special judges and ordinary chancellors, if you like. This is particularly going to affect the grade 1 and grade 2 star buildings, I think. And how are the particular cases going to be identified? Which way will it go? And who's going to do that? I think that's a real issue that has to be faced. In any case involving heritage questions which warrant the special treatment that she suggests, there may be all sorts of other questions thrown up. Are these issues also going to be diverted to the special judges for decisions, or are they going to be kept for the Chancellor? However that's going to be resolved, there may be difficulties about who's going to adjudicate about what. I think this will lead to greater complexity and mechanisms for moving a case from a special judge to the Chancellor or the other way. And are these special judges going to have any other expertise? How are they going to be identified? Apart from the expertise, what else do they have by way of qualities? If the problem is, as she indicates, is to overcome a definite slant by chancellors in the way they decide these cases, the logic seems to me to be this: if that special slant that she says is there arises from being a member of the Church of England, isn't it logical, really, that these special judges are not members of the Church of England? Possibly not members of any Christian church at all. I think that's a very difficult question, but it needs to be looked at. There is, however, a further complication. Section 35 of the consolidating measure of 2018, which brought together all the various bits of ecclesiastical law relating to the faculty jurisdiction, says that any person carrying out functions of care and conservation under the measure must have due regard to the role of a church as a local centre of worship and mission. Now, that was originally enacted in the first of the modern measures back in 1991, and it came from a suggestion on the floor of Synod, and it became Section 1, a very important symbolic section in the Act as it was eventually, in the measure as it was eventually passed. Well, how are these special judges that Kate speaks of going to abide by that, or is it simply going to be abandoned? I don't know. But I do know that an understanding of worship and mission can only come by being part of and experiencing a local expression of church. You can't understand what worship is by watching reruns of songs of praise. And you can't understand what mission is, and admittedly, it's not an easy to understand concept, by concentrating solely on the good that churches do by running food banks or initiatives for the homeless or running social clubs for the elderly or for the young. I think it's something that you can only get by being part of a local centre of worship and mission. So I think of Kate's suggestions that again further traction. There are a number of difficult issues that need to be worked out convincingly. Although I don't favour any particular change at the moment, I do note that the most worshipful Charles George, our last dean, wrote a very powerful article in the the Ecclesiastical Law Journal for September last year. Do we still need the faculty system? And he wasn't by any means defensive. He pointed out quite a number of defects in where we were. And I think overall, I detected that he thought that chancellors were not sufficiently aware of heritage things in making their decisions. I don't personally think this is as serious as that sounds. We're not individually or collectively, as chancellors, experts in regard to architecture, conservation, bells, stained glass, organs, paintings, general matters of aesthetics. I know that. But in my view, our task is to assess the evidence and arguments that are put in front of it. If I tried a case about a baby that had been injured during the course of its birth and the care given to its mother by those attending, back in the late 1940s, this one, I didn't need to be an obstetrician or gynecologist. If I tried a case about a lift that had broken down at an exhibition centre and who should pay for the expensive repairs and the loss of income to the centre, I didn't need to be a mechanical engineer. And if I had to give a definitive answer to the question, how tall is this pony? And I did have to do that on one occasion. He was called Norman, as I remember, by his family. I didn't need to have any expertise in regard to equines, and certainly not be a veterinary surgeon. Now, I think that experience justifies the view that chancellors don't need to be experts in these things. What they need is to be provided with the ammunition and the arguments to make the right decision. Well, I think we've probably exhausted that to a very large extent. So let's move on to something else. Save, I would say this. I do think broadly, chancellors are well placed to decide all sorts of faculty cases, including those raising the most sensitive heritage issues. I'm sure the decisions we make won't please everybody, but that's inevitable. And chancellors can and do doubtless sometimes fall into error. We certainly differ among ourselves about some things, and we disagree about some reported decisions of other chancellors. Let me just say in conclusion on this, that I am sufficiently aware, and I hope modest enough, to recognize that others can probably take a different viewpoint on that. I always bear in mind that reply given by a witness in the Stephen Ward trial, which arose out of the Profumo affair a long number of years ago. The witness was one of the girls involved, Mandy Rice Davis. She was asked to comment on the evidence of another witness who said that he'd never met her and didn't know her at all. The devastating response was, he would say that, wouldn't he? So my view about chancellors can be dismissed. I much enjoyed the lecture that she gave and the way she gave it. Well, let's move on now to something else. Churchyards and memorials. It always sounds rather fitting, doesn't it? That a church has its own churchyard, so the parish priest can lay deceased parishioners to rest or inter their cremated remains. It's a sort of Ambridge view of the Church of England. The reality is that a churchyard is a considerable headache in many cases to the priest and church council, and from that to the chancellor. Issues about graves and memorials raise strong feelings and emotions. And of course, part of the problem arises out of the very different understandings of death and burial, which arise in the minds of clergy as compared with members of many bereaved families. I know a bishop who was asked to intervene in one of those cases where, over a period of time, the churchyard had become full of all sorts of unofficial additions to the graves. Well, he went along for a view and to meet some of the interested families. And on one grave, he found some of those little solar-powered lights that you can get at the local garden centre. What are these for? He asked. Granny loves to read, the family said. And on another grave, he found a bell. What's this for? So we can ring it when we come and Grandad knows we're here. Well, as he said, where do you go from that? People's beliefs about death and burial are very much more about remembering the individual concerned, I think, and celebrating that life than reflecting and confirming the sure and certain hope that the church preaches about eternal life. It's really the reverse of the Bible verse that proclaims he is not here, he is risen. There's this very strong sense among the family. He or she is still very much here. Well, even recognizing that as the background, it doesn't really help very much, I know. I suppose most clergy would turn to the churchyard regulations if they've got some particular problem. Chancellor Miners, in one of our meetings a few weeks ago, said that a few years ago, in comparing one set of churchyard regulations in one diocese with those in another, you would definitely see a family likeness, but he doubted if that was still there. And my experience is that different sets of regulations are now, they're much longer, they're more diverse, they're generally designed to give much more explanation about what their purpose is and what lies behind them. Most lay people find it very difficult to believe that when a relative has been buried in a particular grave plot, that the plot is still really part of the churchyard. We paid for that, they say, when asked to move curbs or little fences or pebbles or ornaments and toys that have gathered there, so we can do what we like with it. Well, of course, it isn't right. Payments at the time of a funeral are statutory fees, or in connection with the undertaker's services. They're not about selling a burial plot. There's nothing about changes of ownership involved. And that's so even when there's a formal reservation of the plot beforehand. So I do think that trying to provide more explanation is a good idea, but I fear that the increasing length of some of these documents gives rise to the law of decreasing returns. They're too long, they're too complicated, and people just fail to read them carefully. They don't take in the whole. Well, having suggested that might be the first point where the clergy went to try and get some help, I think I can hear some groaning even from here, because I'm sure that interaction with the regulations or the Chancellor or the Registrar about some particular problem often gives rise to the feeling, well, that didn't help very much. I always try to get the clergy to understand, not with 100% success, I know, that essentially the regulations set out what they, the parish clergy, may authorise under the authority the Chancellor gives them. If there wasn't that delegated authority for the priest to say yes or no to a particular proposal, then we'd be overwhelmed in applications for particular memorials. And by setting out parameters of materials, design, size, and so on, in modest limits, to which no objection could reasonably be made, then the priest, herself or himself, simply approves it or can do so. It's quick, it's simple, it doesn't involve the payment of fees. That's the purpose, I think, of churchyard regulations. That's the central point of them. They're concessionary or facilitative, which I think I heard the Chancellor say the other day. Clergy should never feel obliged to defend the regulations. Now, I suspect most chancellors would accept that explanation of what they're all about, although they might well formulate it rather more succinctly. But I think most lay people, if asked to read through churchyard regulations, would probably come back and say, well, it's really about what you can and you can't do in a grave space in relation to memorials and so on. That's what it's really about. And that isn't a view which is confined, I'm bound to say, to lay people. I hope many of you have come across the wide-ranging book by Professor Heather Conway at Queen's University, Belfast. It's called The Law and the Dead, and it's very fascinating. It's recently been republished by Routledge at an almost affordable price. She refers at various points to the churchyard regulations, but confesses to having difficulty understanding the legal basis on which they've come into being. There's no statutory basis, of course. They're simply a creation of the Chancellors. I think part of her confusion arises from the fact that sometimes she lumps together churchyards and local authority cemeteries. In fact, of course, they've got very different ways of governance, but that's something I think that she needs to consider when there's a new edition. Well, sadly, the church regulations don't certainly resolve all problems. One of the things clergy struggle with are requests for odd inscriptions. These go well beyond Spike Milligan's "I told you I was ill." Some extreme examples seem to have cropped up recently in the last couple of months. One of them, Chancellor Eales had to deal with in Leeds, an immensely long suggested inscription, which he had to cut down. One of the other problems we've had, of course, is the question of how far can foreign languages be adopted? In days gone by, in our older churches and cathedrals, you'll find many inscriptions in Latin, the odd foray into Greek. Certainly, I've allowed applications for the use of Manx and Irish Gaelic and Cantonese or Mandarin, I don't know which it was. As far as I know, we still await the full judgment of the Court of Arches in a recent case that has been considered there. But a more difficult question, I think, arises about the use of terms relating to family relationships. Any modern part of a churchyard is likely to have many memorials using mum, dad, grandma, and granddad, and so on. Most clergy will approve those without any difficulty under the authority that they have from the Chancellor. I think most of you will have heard the story that Queen Mary I asserted that on her death, when she was opened up, the word Calais would be found on her heart. Well, one experience I had many years ago leads me to believe that the word Freckleton will be found on mine. Freckleton is a village on the Ribble estuary, not very far from Lytham in Lancashire. A son and daughter-in-law approached the incumbent saying they wanted to put up a memorial to their father-in-law and father, as it were, with these words: a devoted and much-loved husband, dad, and granddad. Apart from the first difficulty, which is knowing how many D's there are in granddad, that was a request which I think many clergy would have just waved through, as it were. But the incumbent at the time declined to approve that, saying that on a formal edifice with an inscription that was likely to be in place for a century or more, they should use formal descriptions of family relationships like father and grandfather. Well, the petitioners weren't having that. They said these informal expressions were used in the family. The deceased himself had used them, and they conveyed a warmth and affection existing in their mutual relationships in a way that the formal terms didn't. Well, there were some other minor contentious points, but that was the main issue. And eventually the case came to me. So I had to decide whether this was a case of dad or no dad. Whatever your initial reaction to what the vicar had said about this, he could forcefully argue in favour of his view what the churchyard regulations that were then extant in the Diocese of Blackburn said. He could also rely on the nationally produced document, the Churchyard's Handbook, the third edition and the two earlier ones, and also his own determined efforts over the previous few years to get formal wording adopted, which had been fairly well acceded to by families. I ought to say that before and after the hearing, the case had generated a certain amount of attention in the newspapers. Well, I prepared and circulated my judgment. I took the view that it would be better not to have these informal expressions. And I went away on holiday. One day, La Rochelle, I went into a newspapers, went into La Rochelle and bought a newspaper, the Times de Londres. If you don't ask for that, you get something very different. And on opening it, quite unexpectedly, I found a long news item about the case, adorned with pictures of the Chancellor in full fig. The registrar also fully attired in his legal gear, though obviously at a reduced scale to show his lesser importance as compared with the Chancellor. And then a picture of the petitioning couple, even more diminished in size, to show doubtless how they'd been oppressed by the ecclesiastical legal establishment. Well, I scuttled off down a back street. I didn't want to risk being recognised by any other English people in the area. An early reaction to the case was that several articles in the papers and magazines were published strongly criticising the decision. William Rees-Mogg, sometime editor of the Times, a distinguished journalist, also, I suppose we could say, Jacob's dad, was one critical commentator, and Diamond, a very well-known broadcaster and journalist at the time, was also critical, and so was Steve Chalk, writer, church minister, he published an article in OK or Today magazine or some celebrity publication of that kind. It was a real ecumenical lambasting, if you like. Rees-Mogg was a well-known Catholic. Steve Chalke is a Baptist minister. And Anne Diamond, I suppose, represented all other right-thinking people. There was a further complication. During the hearing, one of the petitioners had indicated my decision went against them. They'd seek permission to exhume Dad for burial elsewhere. Well, I rose to the debate, and in my judgment, I said that I wouldn't allow that on the ground that not getting what you want as an inscription was not a sufficient justification. Well, despite that warning, a few weeks later, I got a petition, and I then made what most of you will be thinking, I hope anyway, made the right decision being faced with that. I could see that I would be accused of prejudging the matter, not having heard argument about it really. And so I asked a neighbouring chancellor to deal with it, which he did, and he granted it. So somewhere, but not in Freckleton, there is a gravestone in memory of this particular individual, proudly declaring he was a much loved dad and granddad. Most chancellors, as far as I could tell, thought I'd gone mad, or as they would have said, fallen into error. My wife certainly thought I was balmy, and my two sons saw this as an opportunity over the ensuing years to tease me and say they were thinking about what they could put on my headstone in due time. This became more serious when my grandchildren stopped calling me granddad and began to call me Grumps. No idea why. So if the Chancellor of Leeds ever has to adjudicate on this, I hope he will confidently say no to the word Grumps. This is still a real problem. I notice in the Church Times for a week or two back that Chancellor Pittaway declined a request for the words pappy or pap for a deceased grandfather. It's a real problem, I think. Lizzie, how much more time can I decently take?
John, I'd say about 3 minutes.
All right, well, that's a shame, really. We haven't got to the detail, but anyway, there it is. Okay. I was going to say something about exhumations as well. There have been many applications, I suppose, over the years the chancellors have had to deal with, and the present position is that unless it's an exceptional case, then you have to refuse it. One I had to deal with before that principle was so clearly enunciated involved a petition by the parents of a young man in his 30s or so who died suddenly. He was a married man. His widow had arranged for his burial in a double-depth grave in the churchyard of a small village in East Derbyshire. The petition was on the basis that they found it very difficult to visit the graveyard and grieve for their son because of the circumstance in which he died. And they wanted to be able to exhume his body and take him to another parish in the neighbouring diocese where they lived. Both clergy were agreeable to this, but his widow certainly was not. She was vociferous in her opposition. In the normal way, the wishes of a widow would decide the issue. However, and I haven't told you this yet, this young man had died suddenly because she'd plunged a large knife into his chest. She was eventually charged with murder, which might have, if convicted, have rather taken the wind out of her sails on this issue. But eventually it was dropped to manslaughter. She pleaded guilty and was given a suspended sentence. She continued to say, despite these unfortunate circumstances, that she wanted eventually to be laid to rest with him. Notwithstanding that, before I ever got near the case, she had sought more present consolations elsewhere and married somebody else. Well, the hearing in the church was noisy, it's very raucous, things were being shouted, which should never be shouted in church. It was very difficult to keep order. And I had to warn those present at a certain stage that I would abandon the hearing if they didn't calm down. That doesn't leave you many places to go. I'm sure any chancellors listening to this sad recital, I believe they would have coped more effectively. Anyway, I gave a written decision. I allowed the parents' request and ordered that following the exhumation, he was to be buried in a single depth grave in the other churchyard. And the Chancellor of that diocese was to rule on the wording of the proposed inscription.
John.
I don't know if there are real lessons to be learned from that. You can hope for the best, but sometimes the worst turns out to be the case.
John.
That's it. Right. I'll stop.
Sorry to interrupt you mid-flow there. Thank you so much for that. Really wonderful, entertaining hour. I think I'm vindicated in my introduction to you, where I said you were patient, tinged with subtle irony. I think we got lots of that in there. And thanks for setting it in a context for us. Starting with that the church buildings are pivotal to the community, and also for setting out sort of the training that chancellors do, because not everybody knows that, and that's what people want to hear. And also, I think this is the first ever that we've had in this lecture responding to an earlier lecturer. And because we're running out of time, John, you will not be surprised to know that Kate is actually with us this evening, and Kate has responded to you in our chat box. But I'm just wondering if is Kate still here, Russell? Can you see her?
Yes, she is.
Kate, can we unmute you so you could put your point and question to John, please?
Hello, yes. There's a danger of barking now. I've unmuted, I'm afraid, and not me. Yes, a few points. That was really interesting. Thank you very much, John. Really, my point was not about Duffield being wrongly decided, although we think it was, but that it's now used as a sliding scale, so that however much harm there is deemed to be to the heritage, to the church, to the fabric, the parish need is always found to be just a little bit higher. And rather like Highbury Magistrates Court that boasts about a 99.5% conviction rate, which doesn't actually make you think it's a fair place, we're rather getting to that stage with the consistory courts where nothing the amenity societies can do means that they win. And as I put in the chat, other amenity societies have pretty much given up on the court system, thinking it's a waste of their charitable funds. The VICSOC doesn't want to go to that council of despair, but we really do want to see heritage to be listened to more. And I know justice delayed, justice denied, blah, blah, but I don't really think that applies as much when we're talking about heritage that's been there for hundreds of years. I think it's far better to get it right than be bounced into going ahead with our experts not properly instructed, that sort of thing. And my final point was that unlike baby deaths, and I do baby deaths too, where we listen to the experts, some of the examples in my lectures showed that chancellors, not all, some chancellors don't listen to our experts. So And our main view, I think, is that we don't really think much of the exemption. Our suggestion of a panel with a range of experts is simply an alternative. And I'm not suggesting it's all heritage people, liturgy, worship, and as I said in my lecture, actually, some architectural historians do get liturgy, they are Christians, so there is some crossover there.
Kate, thank you very much. John?
Yes, I mean, there's not going to be an easy answer to this. I think we need to talk together, and I think Charles George's suggestion that it's time for another substantial review of how things are done is underlined by what Kate says. But we won't always agree on things. But I don't think we can go on ignoring the fact that there is this feeling that it's not a level playing field. So I have to deal with that. I won't have to deal with it, fortunately.
Okay. Thank you, Kate. So let's watch that space and see if we can take this debate further forward. John, we've got a question from Olga Pierce. And he's asking a question about the EGA. Russell, can you find Olga to unmute him?
I think I am unmuted.
There you are. Yes, Olga, please ask your question.
Yes, I go back a long time in this. I mean, I'm not saying I go back as far, but you have been consistently involved, John, with the faculty of jurisdiction, whereas I ceased to be involved with it some 30 years ago, and I could well be out of date. But when I was involved with it, I was aware of an organization that wasn't spoken about very much, called the Ecclesiastical Judges Association. It was the Chancellor's equivalent of the ELA. Wait a minute, have I got that right? Yes, the ELA, the registrar's body. And I know that at that time, some of the chancellors with whom I had to deal found it quite useful that such a thing existed. I wondered if you would just, if it does still exist, say a little bit about it, or if it certainly it did exist then. Was it helpful? Does it is it something we should know a little about?
I don't know how much you should know about it, but it certainly continues to exist. Tim Bryden is the chair. It meets sometimes. Its standing committee meets more often. It is a useful body, in-house body. There must be only, I suppose, something of the order of 30 to 40 chancellors and vice chancellors in the Church of England. But it does meet. It's not a huge body, but matters of mutual concern are discussed with great seriousness and sometimes great benefit.
Thank you.
Thanks, Olga. There are a couple of comments coming in the chat box, but I am conscious that we're past 6:30. We've still got 47 participants, so I think we can keep going for 5 more minutes, John, if that's okay.
It's certainly all right with me.
Okay, so Edward Dobson, would you like to ask your question?
John, thank you. Just to change tack slightly, although it's a separate appointment, there are a lot of diocesan chancellors who sit or have sat as chairs of bishops' disciplinary tribunals under the CDM. Do you have any reflection on that measure and what you think the future might look like?
Well, as we all know, among those who've criticised this, there have been a variety of responses to it, and perhaps the most thought out is the one under the working party chaired by Peter Collier, which is a splendid piece of work. I was vice chair of the Central Tribunal dealing with disciplinary offences for 10 years, I think. Things weren't as difficult there, to be quite honest. we were only beginning to be concerned really about safeguarding it in the way that it now features in the life of the church when I gave up. I think a lot of the criticisms that have been made, which have been directed at the measure itself, really relate to things which aren't in the measure or even in the disciplinary rules, but to be found in the code of practice. And the criticisms essentially are these haven't been carried out. But they haven't been carried out because the dioceses have failed to appoint people to support respondents and complainants and so on. It's not a fault of the measure. It's a fault, I think, that arises elsewhere. I think also that the original measure did deal with the things that need to be dealt with. It had to tell us what disciplinary offences were, who could make complaints about individual clergy or bishops, and so on. So although people are saying it's got to be scrapped as a whole, I certainly feel very much that the things that the measure dealt with really would have to appear in any new measure in some form. I'm not saying there couldn't be changes in how you defined offences and so on, but I think they have to be there somewhere. There has to be clarity. I thought the criticism was overfacing, really. I thought it was far too high, and I thought it very odd too that complaints about how it all worked were from those who'd been put through it, really. And I'm sure it's an unpleasant experience. I don't question that, but a disciplinary proceeding in any walk of life, if you're an accountant, a solicitor, a member of the bar, whatever it is, it's not bound to be a pleasant experience. I think some of the criticism really was just odd, but there it is. Okay.
Thanks, Edward. I'm conscious, John, that we probably should let everybody go and start their evening, and you go and get your well-deserved glass of wine. We would normally thank you in the usual way by a warm round of applause. We can't do that virtually, and these meetings just always end so abruptly. We're just going to all zoom off. But thanks so much, John. It's been really super, and thank you, Kate, for coming back to John's comments, and we hopefully will get some further work out of that. And thank you, everybody, and good night.